Welcome to The Explainer. If you're gearing up for the bar exams or you're just finding your feet as a new barrister, then this is for you. Today, we're jumping straight into the rules of witness examination. This is the tactical toolkit you absolutely have to master to make it in the courtroom. All right, so here's our game plan. We're going to follow the entire life of a witness in court. We'll start with how you handle your own witness, then we'll get into challenging their witness, and finally, we'll cover the absolutely crucial rules of fairness and finality that really hold the whole process together. Okay, first up, mastering your witness. You'll hear this called examination in chief. This is your home turf. This is where you lay out the bricks and mortar of your case through your own witness. So these are the absolute fundamentals. Your questions have to be about the facts of the case, right? Not just trying to make your witness look like a great person. You can't ask them questions just to pump up their tires. Like, you have a fantastic memory, don't you? And what if your witness doesn't say what you expected them to? Well, generally, you're stuck with it. You can't turn around and attack their credibility. You just have to roll with the punches. Now, this brings us to the big one, the most famous rule of examination in chief. You cannot ask leading questions. Look at the example. The improper question, what did you do after the defendant attacked you? It assumes a fact that might be in dispute. The fact that there was an attack. It basically puts the answer right in the witness's mouth. The proper way? What happened next? It's open, it's neutral, and it lets the witness tell the story in their own words. So witnesses have to testify from memory, but there's a really important exception. They can refresh their memory from a note or a document. The catch is that note has to have been made contemporaneously, at or near the time of the event. And what does that mean? Well, it's totally up to the judge. As you can see from these cases, it's a bit of a gray area. 22 days was considered fine in one case, but 3 months was way too long in another. This is a classic evidence exam question, so get your head around it. All right, Section 2, challenging their witness. This is where the gloves really come off. Welcome to cross-examination. This is your chance to really test, probe, and dismantle your opponent's case. So, get this. Pretty much the entire rule book just gets flipped on its head. Remember how leading questions were banned in chief? Well, in cross, they're not just allowed. They are your primary weapon. They are essential for controlling the witness. You can go anywhere you want. Any topic that's relevant to the case, or even just to the witness's credibility. But, and I can't stress this enough, look at that last point. Once your own witness is being cross-examined, you cannot talk to them. Not a word, not a nod. A breach of that rule is a massive deal and can get a mistrial declared. Okay, now for a rule so fundamental, so important, it's often just called the Great Rule of Fairness. If you're sitting the bar exams, Browne v. Dunn is not just something you should know. You must know it, backwards and forwards. At its very heart, the rule from Browne versus Dunn is all about preventing an ambush. It's simple, really. If you're going to call your own witness later to say something that completely contradicts what the other side's witness is saying right now, you have to put it to them. You have to give them a fair chance to respond to your version of events. No saving up a gotcha moment for your closing argument. It's about basic fairness. And look, this isn't just some dusty old technicality. It serves 3 really practical and important functions. First, it's fair to the witness. They get to explain the contradiction. Second, it helps the court. The judge or jury gets to hear both sides of the story right then and there, which helps them figure out what the truth is. And third, it's fair to your opponent. It puts them on notice that you're challenging this part of their case, so they can call other evidence to back it up if they have it. If you ever need a simple way to remember this rule, just think of the grapes on the floor case. A woman said she slipped on some grapes in a supermarket. The defense barrister barely asked her about it in cross-examination. But then, in his closing argument, he tries to tell the jury, hey, there was nothing on the floor. The court shut him down. You can't do that. You never put your case, that the floor was clear, to the witness. You didn't give her a chance to respond, so you lose the right to make that argument. Let's move on to another concept that can really trip people up in exams and in practice, the finality rule. The easiest way to think about it is as a traffic cop for the trial. It's there to keep the case focused on the main issues and stop it from getting bogged down in endless sideshows. Okay, put simply, if you ask a witness a question that has nothing to do with the actual facts of the case, but is just about their general credibility, what we call a collateral question, you are stuck with their answer. It's final. You can't then call a whole other witness just to prove they were lying about that little side issue. The court just draws a line in the sand and says, we're not going down that rabbit hole. This famous old case from 1858 just makes it perfectly clear. An Irish witness was giving evidence through an interpreter. In cross, he's asked if he was heard speaking English in the hallway, and he denies it. Now, whether he could speak English or not wasn't a fact and issue in the trial. It wasn't part of the crime. It only went to his credibility. So the court ruled his denial was final. They weren't about to pause a criminal trial to have a mini trial about his language skills. However, and this is a massive however, absolutely critical for your exams, the finality rule has some really big exceptions. If that collateral question you asked happens to touch on certain really powerful credibility issues, things like bias or a prior criminal conviction or a prior inconsistent statement, well, the court says those are too important to just let a denial go unchallenged. In those situations, you can bring in other evidence to prove the witness was lying.
All right, so imagine your witness has just been put through the ringer in cross-examination. Your opponent has twisted their words, made them look confused, or gotten an answer that sounds terrible out of context. What do you do? Well, that's where re-examination comes in. It's your chance for a comeback.
Think of re-examination as damage control. It's your opportunity to let your witness clarify an ambiguity or explain an answer that came out badly. But, and this is really important, the scope is incredibly tight. You can only ask questions about things that came up in the cross-examination. This is not a second chance to ask questions you've forgotten, Chief. Its only job is to repair damage or clear up confusion caused by your opponent. Now, here is a really powerful and strategic use of re-examination. Normally, you can't bring up a witness's past statements just to show they've been consistent. But if your opponent in cross-examination suggests, even subtly, that your witness has made up their story recently, that they've fabricated it for the trial, well, they've just opened a door. You can then walk right through it in re-examination and introduce a prior consistent statement to show the jury, hey, this isn't some recent invention. This is the exact same story they were telling from day one. So there you have it. That's the framework, the rules of engagement that you have to know cold for the bar exams and for day one in court. But the real art of being a barrister, of being a true advocate, isn't just knowing the rules. It's understanding the strategy behind them. It's developing the instinct for when to push the boundaries, when to take a calculated risk, and when to sit down and shut up. That is the ultimate test.